All right, first of all, thanks to everybody. I'm Catherine Asaro again, and thank you all for being here. Thanks for being a patient and wonderful audience during our first half of the day. And we have an amazing second half of the day for you, too. We have 3 sessions total, so 2 sessions, then a beautiful snack break with cookies and brownies and cupcakes to give you some energy. And then we are ending the day with the mental health portion that is being done by the Red Cross of North Carolina, so thank you all. So I'm going to introduce our next 2 speakers here next to me here. So first of all, we have, I'm going to read because they are new to me too. Jeb Saunders. Jeb is the Special Deputy Attorney General for Consumer Protection Division of the North Carolina Department of Justice. He is the director of the Elder Fraud Unit within that Consumer Protection Division. And in addition to elder fraud, his areas of expertise include home contractor fraud, appliance and retail fraud, and tax preparation fraud. He is a UNC Chapel Hill graduate, where he was a Moorhead Scholar, and then got his law and master's degree in English from Duke University. So fellow Dookie, I like having that. And after which he entered private practice. He practiced law in Michigan for 15 years and then came to North Carolina to do his current position. And then we also have Kip Sturgis next to me, Special Deputy Attorney General for the North Carolina Department of Justice. For 5 years, he was an administrative law judge in the Department of Natural Resources and 2 years in the Environmental Division. He then began enforcing state and federal antitrust laws in the North Carolina Department of Justice. His practices included pursuing claims of attempted monopolization, bid rigging, horizontal and vertical price fixing, invitations to collude, and anti-competitive managed care contracting. He was also cross-deputized to assist with federal grand jury antitrust investigations. He has been admitted to practice, I'm not going to list everywhere, all over North Carolina and all the different federal courts. And let's see, he is a graduate of Penn State and then earned his JD from Duke University. So right now we are going to be talking about consumer fraud issues in North Carolina after natural disasters. So I turn it to you. Thanks. Oh, sorry, and before I start, their talk is focusing on 2 statutes, which everyone should have gotten a paper copy. So did anyone not get that? Because Sylvia has them if you don't. Raise your hand high if you didn't get the paper copy of the statutes, and we'll bring those to you. All right, thank you.
Thanks, Catherine. Okay, we are in the dreaded post-lunch hour. We're going to try to keep you awake. We're fighting the food coma. We're aware of that. We'll try to keep it lively. Thank you, everybody, for being here. It's wonderful to see faces that aren't the usual defense attorney crowd. We appreciate all that you do. And we've had some very good dealings with pro bono attorneys. How many non-legal services but pro bono attorneys are there here? Not too many? Well, yeah, a few, okay. We've had really, really good luck, and thank those of you who take time out of your practice for helping people who get hit hard in these disasters that we seem to have more and more frequently. The first statute that we have a very narrow perspective. I have a very narrow perspective in the disaster times because somebody said enforce the price gouging statute, here do this, and so that's sort of added on to my usual selection of stuff. It's much narrower than many things that will come across your plate, but it has very broad applicability. If it's pulled up on your screen there, it applies when any person sells or rents or offers to sell or rent. The offering part is probably less important to you because unless it culminates in an actual transaction, your client isn't going to have been harmed. That's more important to me as an enforcer because I can still tag them for simply offering to sell gasoline for $8 a gallon or plywood for $50 per sheet or whatever. Just the offering is something. But if you do run across that, and even though you may have a client who's not been injured, you may still want to flag it to us because it's that offering that we can go after, even though you may not have actual damages. So it applies to any person who sells or rents or offers to sell or rent. So that can be housing, it can be renting a generator, it can be a lot of things that are sold or rented. Plywood is something that down east we find people are scrambling to get when there's a hurricane approaching, or tarps or whatever to put on the roof. A lot of practical things. We also have food. We first started with the price gouging statute dealing with gasoline a long time ago. And because we had the refineries down the Gulf Coast get hit, and when they would shut down, then the pipeline that starts at Beaumont, Texas, comes all the way up to North Carolina and on up into Virginia, that pipeline gets shut down. So there's no more gasoline, and everybody's lining up, and the gas stations are doing their thing. But again, if you may not have somebody who's come to you and said, hey, I just paid $50 a gallon for gas. You may have somebody who just said, there's this gas station down the road. Please give us a call. We have a website where you can put in the information. Be glad to gather that information. We have sheriffs across the state, SBI agents who call in stuff that they see. We get our information from lots of people, in addition to the regular consumer complaints that come across the transom. So let's look a little bit more at this statute. Offering or selling or renting any goods or services consumed as a direct result of an emergency, or which are consumed or used to preserve or protect or sustain life, health, safety, or economic well-being. Well, that's a lot of stuff. That's going to be your plywood. It's going to be your milk or your generators or many other things. Just staying alive after an emergency, if you have to buy food and you're paying $5 a loaf for bread, I think that's squarely within the statute. The goods that are defined here, they don't have to be personal or household goods. We'll get into another statute in a minute that is limited to personal or household goods. This one is very broad. So things to sustain life. It doesn't have to be just an individual consumer either. It can be a business that's seeking plywood to put up on their storefront where a window got blown out. So this statute is not limited just to consumer transactions. Then what's prohibited is charging a price that is unreasonably excessive under the circumstances. And you can have a lot of fun with this. There's a fair amount of leeway. The statute does give several guidelines. In A subsection 2, the price charged, I'll try to scroll down here. So they're in the provisions that are now up on the screen. If you look at the second one, the price charged by the seller exceeds the seller's average price in the preceding 60 days. You're not going to know that as a matter of fact, but you're going to have gone to the grocery store and bought milk, or maybe a neighbor will have bought plywood, or some of these other things where you have an intuitive sense, or more than an intuitive sense. Gasoline you're going to know about. Rentals, apartment rentals, you're going to have an idea. You'll be able to develop sources. That's a big one that happened this last time with, what was the big one before? Florence. We had a lot of people at the coast displaced from their homes, having to rent someplace new, and the landlords were having a field day with them. That's an area that can be explored. And what helps you all is that if you look at the very top of this section, it's prohibited and shall be a violation of GS 75-1.1. Well, that gives rise to treble damages. So your folks, if they're charged an extra $500 a month for rent, they can get treble damages. And then you've got a shot at attorney's fees too. It's a very helpful statute. So if a landlord is looking at, gee, I'm going to be paying 3 times as much out as I was able to bring in, I better not do this. I think you've got a pretty good stick to wave at them. So I'd really encourage you to take a look at that. The lower ticket items, bottled water, they're just really not worth going after. But the bigger ticket items like a generator or rent and that sort of thing, they are worth going after. And it's a real stinger for the landlord. It's not price gouging if the charge is attributable to additional costs imposed by the seller supplier, or the seller simply had additional costs. Had a generator complaint several hurricanes ago, and it turns out, we called up it was a hardware store. We called them up and just said, we got this complaint. Can you tell us your side of the story? And he said, well, I contacted a generator manufacturer in Ohio. I rented a semi-truck. I paid a driver way overtime to bring me a whole truckload of generators in case my community needed them. And I just said, bless your heart, thank you for helping. But he did incur extra costs. He took some big risks, because if the power came on the next day, he was stuck with a truckload of generators. So that's where he was doing a service. Yes, he was charging more than he used to charge, but there was a reason for it. Now, what triggers the price gouging statute is a declaration by the governor of either a state of emergency or a state of abnormal market disruption. What we found with Hurricanes Katrina and Rita, sometimes called Carita, is that they affected the oil supply and the gasoline supply down the Gulf Coast, and they shut down the pipeline. But that was way down there. There was no emergency up here. There was no state of emergency in North Carolina. We didn't get hit by them. And so that was back in the days when we could ask the General Assembly to amend the statute, and they would. And so they amended it to add this abnormal market disruption, because it was a serious problem. There was no gasoline in North Carolina for a good spell of time, and we didn't have a way of addressing it. We did have retailers who had gas in the ground, and they were selling at a normal markup from what they had already paid. But some just, I had one retailer who owned his tanks and he owned the gas, but his supplier came around and told him, raise your price. And he said, well, no, I already paid for it. It's my gas, it's in the ground. And he wouldn't raise his price. So the jobber padlocked his pumps. He had no right to. And we learned about it because the jobber's attorney was quoted in the newspaper saying, yeah, he wouldn't raise his prices. So it's like, a big target on his chest. So I popped them for vertical price fixing, but not price gouging. But there are more stories to tell about that case, but I won't get into them right now. So any questions on the price gouging statute about its reach? It applies to sales and offers and leases of whatever you need to protect life or property. It's not consumer goods. It doesn't have to be a consumer transaction. And what is an unreasonably excessive price? For our enforcement cases, we don't take iffy cases. We don't get them so they're close. We get them so that they're shocking. They shock the conscience. We had one case with a judge who's, in my experience, very mild-mannered and somewhat defense-oriented. When we told the judge that it was a tree case, and they put a tarp on the guy's house, just a regular house, 2,000 square foot house. They charged him $7,000 to put a tarp on the house, and when my colleague, informed the judge that they charged him $7,000, and he started to continue with this argument, the judge said, "Stop right there. Bring me the order." So, $7,000 for 45 minutes of work, 2 men with a tack gun. That shocked the judge's conscience. It helps to have comparison prices. With our tree cases, we had a bunch of them following Florence down east, trees being knocked down onto people's houses. We break those down into dollars per man hour. We find out how many people are in the crew, what equipment were they using, did they have to have a crane? Cranes can be expensive, so that's kind of a wild card. But if they just had a bucket truck and a skid loader and 4 typically men with chainsaws, or 2 men with chainsaws, you break it down to dollars per man hour. And anybody have a guess about our highest dollars per man hour for guys with a chainsaw is? I think $200, $500, $5,400 per man hour for men with chainsaws to cut a tree off of a lady's house. And, it just said, Judge, if that's the going rate, we're in the wrong business. So, some of these businesses will give you a lot to work with, but if you can find a way to break it down into a figure like that, dollars per man hour is very valuable with a lot of these services that you're looking at. You look at if they're repairing a roof or whatever it is, you can figure out the cost of their supplies and you figure out the dollars per man hour, and that will help you a lot. Another area where we had problems with following Florence was flood remediation. A lot of places in New Bern particularly, down there along the Trent and the Neuse rivers, got flooded because the Trent and the Neuse were actually flowing backwards. The storm tide was blown in by the wind, and then all the rainwater came down. But I remember seeing TV footage of downtown New Bern and the rivers flowing upstream. It was pretty remarkable. That means it was just spreading out, and a lot of people got flooded. You'll find bait and switch tactics associated with price gouging. They'll quote you a low price to muck out your house, and then they'll send you a bill in writing that's for a much higher amount. So be aware of the whole panoply of bad things people can do in association with price gouging, because they get their foot in the door with a low price, and then they sell you a bill for a high price. And we always try to get people to get that initial quote in writing. A lot of people don't do that, and it really comes back to hurt them, because then the contractor will say, I never quoted him $5,000, and then send him a $39,000 bill. We have some of those. If you can put together several consumers who have had the same experience, that really helps. If you've got several instances of lowball pricing and then high bills, that really helps you to put those cases together. So yeah, those are the principal things that we've been doing with the price gouging statute. Happy to entertain any questions or comments. Yes.
I think two questions. The first one is, if before the storm someone hires someone they buy plywood and have someone come do it and they get way overcharged, does the declaration relate back to when they were preparing?
Okay, the question is, someone purchases some goods or services before a storm. They see it coming, and the question is, does the declaration of the state of emergency or market disruption relate back? The quick answer is no. It's triggered upon the date of the declaration, but if you'll notice, during the declarations that we've had recently, I recall specifically with Florence, the declaration was made on September 7, 2000, what year was that, 17, 18? 2018, but the storm didn't hit until the 15th. And so the declaration extended the protection of the law because people were rushing to the store to buy plywood and whatever. So watch. You can pull up on the governor's website executive orders, and that's what these declarations of emergencies are. They're executive orders, EO number such and such. You can pull up and see when they were entered. I don't think they give you the time on the governor's website, but they certainly give you the date. So you can pin down just when that declaration occurred. The governors tend to see things like hurricanes coming and put the word out. That's also part of transportation waivers, so that truckers can work overtime and bring in plywood and other supplies, and they waive weight limits as well. So part of that's the preparation time, but part of that, the governor sees it coming and extends that protection. So any further questions? Yes, sir.
If you had a closer case and someone objected to whether is it a APA, arbitrary and capricious standard of review? What is the standard of review that judge is applying?
To the standard of review of when somebody brings an enforcement action.
Correct.
I don't think it's arbitrary and capricious.
My question is, if you bring an enforcement action and the alleged price gouger disagrees with you and there's a dispute before a judge, what's the standard of review that judge applies in determining whether your action is correct?
It's preponderance of the evidence. This is not an administrative proceeding, or it's not a review of agency action, so that you would have an arbitrary or capricious standard of review. I kind of wish I did, but but no, it's preponderance of the evidence. I think it's the same for you and me, whether you're acting on behalf of an individual client or if I'm doing an enforcement action. Well, that's a really good question. More on price gouging? Okay. Nobody wants to ask what's unreasonably excessive under the circumstances?
$40 an hour.
Yeah. That one kind of jumps out. But we did, in our tree cases, we found an expert who walked us through how he does his pricing. Some of these industries that you run across are part of the underground economy, the tree business in particular. You have people who some guy with a chainsaw, he goes down to the corner, says, hey, you want to come work? He finds some guys who come work. They don't have workers' comp. They're not withholding taxes. They're not reporting taxes. And so you can have some people who are just taking advantage. But this expert we had does all these things. He offers his employees a 401k match and vacation time off and health benefits. So he has all these costs of doing legitimate business to deal with, but he could give us an outline. So oftentimes in some of these cases, you'll need to find an expert, and sometimes it's just the luck of the draw if you can find one or not. We were lucky to do that. Okay. All right, let's move on briefly. One of the statutes that let's see now. Am I there? Here we are. And you're probably looking at this saying, what is he talking about with something out of the criminal code, chapter 14. And the failure to give right to cancel in an off-premises sale. And you'll notice at the top it says, shall be a class 3 misdemeanor. And you go, oh, why are we talking about criminal law here? Because in a case that actually was litigated to the Court of Appeals before this statute, that case applied the federal rule. It's in 16 CFR, I forget exactly where. The FTC has a 3-day right to cancel off-premises sale rule that's applicable nationwide. And the court in North Carolina bootstrapped that into 75-1.1, said it's an unfair deceptive practice to violate this FTC rule. There's Marshall against Miller, some of the classic consumer cases that say violation of a statute designed to protect consumers is a violation of 75-1.1. So you can bootstrap a lot of things into 75-1.1. That case in the Court of Appeals was Eastern Roofing. It involved, no surprise, roofing. And someone was not given a 3-day right to cancel. It was an off-premises sale. And the court upheld the consumer's right to cancel. So you can bootstrap. This statute was passed subsequent to Eastern Roofing, and I think that really enforces the General Assembly said, yeah, darn right, this is illegal, and we're going to make it criminal in North Carolina. While we also have this Court of Appeals case on the books that says this is a civil offense that's drawn into 75-1.1 as well. So this one, unlike the price gouging statute, just applies to consumer goods. Let's scroll down since Sorry if this is okay. Okay, here we have in C1 the definition of an off-premises sale, a sale, lease, or rental of consumer goods or services. This is only going to be a consumer transaction, not a business seeking help in any kind of situation. $25 or more, in which the seller solicits the sale at a place other than the seller's place of business. Now, you typically think about door-to-door sales, and sometimes this statute is called the door-to-door sales rule, but it's literally the off-premises sale rule. And so you could find, for instance, car dealers sometimes have tent sales in parking lots. It's not at their usual place of business. I think there's a really good argument this statute applies to those consumer transactions. But it is limited to consumer goods or services. But again, like the price gouging statute, it involves a sale, lease, or rental. So if just imagine you've got somebody whose electricity is out and it's wintertime and a storm has knocked out the electricity in a wide area, you could imagine somebody going around with a truck, going door to door saying, hey, you want to buy a generator? You want to lease a generator? Do you want to buy a chainsaw? Whatever. These are off-premises sales. And as I say, the typical picture of these is a door-to-door sale, but and that's how we often come across them. We came across these with both tree cutters and flood remediation people following Florence most recently. Dorian fortunately didn't do much to us, although it nailed Ocracoke, but it missed most of the state. So what this statute requires when there's an off-premises sale, you have to furnish in A1, you have to furnish the buyer a completed receipt, and if you look down most of the way down that paragraph, it says it has to have a statement that says you may cancel this transaction any time prior to the 3rd business days after the date of the transaction. Some of the tree folks were mighty upset when they went around door to door, quoted somebody a low price, sent them an invoice for a really high price, and didn't give a 3-day right to cancel. And we came along and said, oh, you didn't give a 3-day right to cancel. You owe them their money back. And they were upset that they had already done the work and so on, but they didn't give this right to cancel. One of them actually argued in court that it was futile for us to raise this statute after they had already done the work. Well, if that's the case, then this statute doesn't mean anything, because if you come by, you do the work, you don't give the 3-day right to cancel, then they can't do anything, then the statute has no teeth. So it's a pretty powerful tool for you all to use, and keep it in mind. There's case law under similar statutes around the country about just when you can give the 3-day right to cancel. There's some case law, which I like, that says until you inform the consumer of the 3-day right to cancel, that right continues forever. So they can come back a year later and give you a written notice. It says, I hereby cancel the transaction. You have 10 days to give me my money back, and if you don't, it's a misdemeanor. You want me to call the DA now, or should we work this out? But this is a negotiation that you can have when you're acting on behalf of people to help them out. So please be aware, when you have disaster times, people are sold or leased consumer goods particularly in connection with a disaster. It makes a pretty sympathetic case. It really helps if you have what we call plus factors in the office. If you have a bait and switch, you have a refusal to quote a price and then an invoice for an outrageous price. If you have other things that make the transaction just feel not so good, that really helps you with the judge. let's look briefly, and I'll turn it over to Jeb. Oh yes, you also are required to inform the buyer orally at the time of signing the contract. So you have to give a written notice of cancellation along with a completed form with the seller's name and address and all that. But they also have to give an oral notice of the right to cancel. There are some quirks in this statute. Let's look down to C. C has several quirks. Okay, if we look at C1, the last sentence, the term off-premises sale does not include if it's made pursuant to prior negotiations that were at the seller's place of business, then that's not an off-premises sale. B is a consumer has a right of rescission under the Consumer Credit Protection Act. C, in which the buyer has initiated the contact and the goods are needed to meet an emergency and the buyer furnishes a waiver. Oftentimes you'll have somebody call up a tree guy or a flood remediation person and say, hey, can you come out and give me a quote? And some of those people say, oh, well, the buyer initiated the transaction, they called us at our place of business, so it's not within the statute. And, but it's only excluded from the statute if it meets multiple tests. Yeah, the buyer initiated the contact, and the goods are needed, and the buyer furnishes a waiver. If you don't have those things, then even when the buyer has initiated the contact at the seller's place of business, if the seller comes out and then gives a quote at the premises, I think you're squarely within the rule. And if you look back up at the C1, where it defines an off-premises sale, it says a sale, lease, and so on, in which the seller or representative personally solicits the sale, including those in response to or following an invitation by the buyer. So the statute tells us twice, the buyer can invite you out there. That doesn't keep you out of the statute. In fact, the definition of off-premises sale says it includes one where it was at the invitation of the buyer that you came on out. So that's one of those little twists. In federal rulemaking, they drafted this as they wanted to. So it's complicated, but I think it gives you room to capture a lot of transactions and get your people completely out of a consumer transaction that was harmful to them through this off-premises statute. As I say, the Court of Appeals case is Eastern Roofing. I want to say from about '86. I could be completely wrong on that, but it's pretty easy to find. Any questions about off-premises sales statute? Okay, well, I'm so glad you all are here doing your good work. Thank you for the invitation. Let me turn it over to Jeb, and he'll share some of his perspective.
It's fun to be here with Kip. It's not like we get to work together on too many things, so that's nice. I'm going to take us a little bit afield from the area of disaster relief. I hope it's okay. I wear two hats in consumer protection. We have a small elder fraud unit that I direct, and in that capacity, we do a lot of outreach, and we work with seniors who have been victimized by scams. We work with financial institutions who may realize that one of their customers is in the midst of a scam, and we can help them figure out how to report the scam and who to contact. And then I'm also the one in the office who sues contractors for Chapter 75 violations. And I don't know if this has happened often, but it's not uncommon where Kip assembles his price gouging team as the hurricane approaches, and then the complaints start to come in, and we realize that maybe the complaints don't really reveal price gouging, but they do point to a contractor who might be doing some bad things, and then I'll look at it for violations other than price gouging and bring a Chapter 75 action that's pretty standard and not too difficult to pull together. And I should kind of take a step back. When we file a Chapter 75 case, we are typically looking to accomplish three things. One is to obtain injunctive relief. And the folks that I sue are just bad folks, and they shouldn't be doing what they're doing. So the idea is to get a judge to ban them permanently from doing that work. The second thing we want to accomplish is to try to get restitution for consumers. And then the third is civil penalties. Under the statute, we are entitled to seek civil penalties of up to $5,000 for each violation. That's discretionary. The judge doesn't need to award that. And I want to say, Kip, I was in the back of the courtroom, maybe on one of your tree cases, where the judge gave you a $2,500 civil penalty for multiple violations, right? So, so that's a nice hammer to be able to use. So, what I'd like to talk about is sort of contractor fraud, and the theme, though, for me at least, is that, and I'm sure you all know this, seniors are victimized disproportionately in disaster situations and in contracting fraud cases as well. They typically are victimized by kind of door-to-door scam artists and so forth. It's sort of passionate for me. The reason I was put in charge of this little elder fraud unit is my father unfortunately got scammed and lost his life savings. So so we really encounter some horrible stories, and I hope we're able to do some good. So let me start off kind of working you through the legal framework whereby a contractor takes money and doesn't do the work. And those are the cases that I bring. So if we receive reports about someone who might be kind of sloppy, and a few people don't like the fact that the contractor hasn't completed some items on a punch list, that's not who we're going after. We're going after the really bad folks who take money and just don't do the work. And sometimes I think that's just a function of pure greed. Sometimes I think it's a function of just kind of business incompetence. These people are kind of robbing Peter to pay Paul, and then eventually their whole sort of house of cards collapses. Sorry, I'm mixing my metaphors there, but you know what I'm getting at. So the framework is this. So the question is, when does wrongdoing by a home contractor potentially implicate a Chapter 75 violation? To show that a practice is unfair or deceptive, you need to show that the act or practice is immoral, unethical, oppressive, unscrupulous, or substantially injurious to consumers. That's the standard. An act or practice is deceptive if it has the capacity or tendency to deceive. So, contractor solicits business from a homeowner, and they agree to have a deck built, and then the contractor takes off with the money and doesn't do any work. Well, obviously the relationship between the two parties is based on the contract. And the law is clear in North Carolina that mere breach of contract, even if intentional, is not sufficiently unfair or deceptive to sustain an action under Chapter 75. So you need to show something more than mere breach of contract. I can give you a cite for that. The case is Estate of Hurst, H-U-R-S-T, versus Moorhead, M-O-O-R-E-H-E-A-D, and that's 228 North Carolina Appellate Reporter 571. It's a 2013 case. And what that case said is that the plaintiff needs to show substantial aggravating circumstances attending the breach of contract. So the next step is, well, what do we mean by substantial aggravating circumstances? And one helpful case is called Allen versus Roberts Construction Company. It's at 138 North Carolina Appellate Reporter 557. And this was a case not involving a contractor doing home repairs or remediation, but rather someone who bought a new house. Plaintiff buys a new house, immediately cracks start to appear all over the place, the foundation, floors, on the interior, exterior. There was expert testimony showing that essentially the defendant had built a house that was structurally deficient in lots of ways. The Court of Appeals affirmed the trial court's decision as a matter of law that the plaintiff had established a Chapter 75 violation through evidence of three things. First, the defendant did not have a general contractor's license. Second, the defendant concealed material facts at the time of purchase, which the plaintiff could not discover through due diligence. And third, the defendant falsely represented that the house had been constructed in substantial conformity with plans and specs that were approved for the house. So I'd like to circle back to the first evidence that the defendant didn't have a general contractor's license. So you probably know this under the statute. If a contractor solicits or does work for $30,000 or more, then that person has to be licensed by the contracting board. And it's not uncommon for a lot of folks out there, some of whom are quite talented and have legitimate businesses, not to be licensed. It just means that if they're following the law, they can't be doing projects or soliciting projects in excess of $30,000. My reason for highlighting that is that if you read some of these cases where the plaintiffs were essentially trying to take what was a breach of contract and show that it was more than that it was an unfair and deceptive practice, that's one of the factors that the courts have looked at, the fact that the contractor did not have a license and should have had a license. So there are other cases out there where the plaintiff failed to show a Chapter 75 violation, and they're kind of interesting reading to me. I can't quite figure out if the failure was in the pleading of the case or just in the evidence submitted. One of these is Dekker versus Holmes, Inc., 187 NC App 658. And this is the case where you couldn't quite tell what the contractor did wrong. It looked like he may have mismanaged some payments. There were substantial delays. And eventually the homeowner got an entry of default. So then the case proceeded to trial on damages. And on appeal, the court held, actually, as they were about to try the case for damages, the defendant tried to get the default set aside. The trial court refused. On appeal, the Court of Appeals held that it was error for the trial court not to have set aside the entry of default. And on the issue of damages for the Chapter 75 violation, the court held that the plaintiff had not established anything more than breach of contract. So the plaintiff was not entitled to damages for a Chapter 75 violation. And here it just strikes me, so the plaintiff files a lawsuit, gets a default, so there's really nothing in evidence at that point contrary to the plaintiff's allegations. And so maybe it's just that the trial and the damages didn't go well. But maybe it's just our experience and the people we sue are particularly bad actors, but it's not that difficult to add facts that will take a breach of contract and cast it in the light of a much worse unfair and deceptive practice. And so, for example, basic allegation is defendant took the money and didn't do the work. So that's the breach there. Well, in all likelihood, the homeowner hung in there for a long time with the contractor and said, please do this work. And the contractor said, oh, I'll get to you next week. And then doesn't get to him next week and then keeps delaying. So you have a second allegation, which is that the defendant promised to complete the project on a certain date and made that promise repeatedly and each time failed to do the work. it's commonplace, right, for the contractor to offer all sorts of excuses for why he didn't do the work. You know, the cat ate my homework. So we have a kind of a standard allegation, which is that the defendant made excuses that upon information and belief were false. And then if the contractor wasn't licensed and the project was more than $30,000, that gets alleged. It's also fairly common for some of these contractors to keep changing the name of their business, and they do it for obvious reasons. If you get online and you look up a business and you find lots of bad BBB reports, you're not going to hire that business, but if it's, so they'll change the name and you won't find complaints under that business. And as a kind of aside, we're starting to find out that that really is one of the problems with these folks online who the sort of portals through which you can find a purportedly legitimate contractor. They don't screen well for situations like that where the contractor keeps changing the name of the business. So here, you know, you had a simple breach of contract, but you add those factors, those allegations, and I think you probably have a pretty good argument that the contractor has violated Chapter 75. So with that, I'd like to, and I'm sorry to kind of rather abruptly shift to kind of the elder fraud component of situations involving contractors who knock on the door. We have a kind of a famous or infamous case in the office involving a guy named Tommy Clack. If you want to have fun after this, after today, Google Tommy Clack Raleigh, and you'll find all sorts of news stories about this guy. He's a paving repair scammer. And Kip, you can refresh me if I'm wrong, but I believe our initial encounter with this guy was that he was in Wilmington in around 2005, and he violated the 3-day right to cancel. And he was charged criminally with like 26 counts of that. So my predecessor sued him under Chapter 75, got an injunction essentially requiring him to comply with the law. Then complaints started to come in which showed pretty clearly that this guy was just a scam artist, and what he would do is he knocks on the door and say, I have some extra materials, I just finished a job up the street, I can give you a great discount, I'll do your driveway for $1,500. So then he does the driveway, and what he does is not real paving anyway. It's pretty crummy. He, fills a couple of potholes and sprays something on the surface. And then he presents them, it's the bait and switch, with the bill for $15,000. And his victims are often elderly. This guy is he's capable of being kind of physically menacing and also quite charming. He likes to talk about how he found God, and God will bring them to a resolution of this dispute over the bill, and eventually they settle on $7,500 or something like that. But people end up paying $7,500 and they get what's not even a real paving job. So what happened is we got an injunction against him prohibiting him from doing any paving. That was like in 2008. He kept violating that, and so there were various contempt orders. And then he was going from state to state. And my predecessor, a guy named Dave Kirkman, some of you may know him, just was absolutely dogged pursuing this guy. Well, what finally happened, fortunately, was he was prosecuted convicted for federal tax fraud. He ended up in federal prison. And the IRS agent locally who was instrumental in this case kept me apprised of when he was getting out. So we knew he was going to get out in June of 2018. He got out in June of 2018, and within 2 weeks, he was already scamming people. He knocked on the door of a 90-year-old woman whom he had scammed before. Fortunately, her daughter was home, recognized the guy, said, "I know who you are," and chased him down the driveway and took pictures of his truck. So we got an affidavit from the daughter. He struck again. We got an affidavit from another victim, and I was trying to figure out, geez, is this going to be the rest of my life, chasing Tommy Clack? in contempt proceedings. But then, fortunately, what happened was we ended up contacting his probation officer. She didn't know there were any court orders out there, so we sent her the 2008 court order prohibiting him from doing paving work, and he said, "Oh, I forgot about that. But the Attorney General has since told me I can do that." And so she said, "Have you all told him that he can do that?" And I said, "Absolutely not." So she let him just kind of talk himself into a trap. And he ended up, I'm not a criminal attorney, I don't quite know how that worked, but he was found to have violated his probation, and he's back in prison now for 18 more months. I don't know when he's going to get out exactly, but I need to know because Tommy Clack is my life, apparently. So, lessons learned. Again, seniors are disproportionately victimized by people like that. And when I do outreach, I have kind of a list of tips for seniors to be aware of. I think it's helpful if you all are aware of these things too, to get the message out. So one of them is if someone shows up at the door and has extra materials, that's a scam. We know that. The other typical scam is someone knocks on the door and offers to clean someone's gutters for $15, and then while cleaning the gutters purports to find some other problem. "Gosh, ma'am, you got holes in your roof. I'll do your roof for you." Or, "Sir, you have cracks in your foundation." So the scam is you do look for one problem and find others. So that's a scam. We tell people to ask if the contractor is licensed. And again, recognizing that some folks don't need to be licensed and do great work and are capable of doing this kind of work well. Personally, I think I would be reluctant to hire someone without a contractor's license. We tell people to be wary of contractors who demand payment by cash or personal check. We obviously recommend written contract with all the language that Kip has worked us through that should be included. If the person at the door has out-of-state license plates or obscured plates, that's a warning sign. If they have a toll-free or out-of-state phone number, no local number, that's a warning sign. And I think that really is it. Again, not to take us too far afield. I think I've done that already, but kind of a recent scam that has us thinking we're going to be needing to file some cases fairly soon involve alarm systems in seniors. So someone knocks on the door and says, "I see your house has that alarm system. I can extend that for you at a lesser amount per month than what you're paying now." And the senior is presented with a tablet and signs a tablet, and lo and behold, they've signed something that has them paying a lot more money with a different company often for a 60-month alarm system plan. And that's bad stuff. I will say that if we get complaints on that, when we send them on to the company, generally we're pretty successful in sort of sounding ominous enough that folks are let out of the contract, and in some instances their money is returned. So that's something good we can do. Big picture, our office can only do what it does if we receive complaints from consumers. And to file a complaint, if you don't know this, our website is ncdoj.gov. There are icons that say how to file a complaint. We have different complaint forms for different types of things. Is there one for price gouging, Kip? So there's a separate...
When there's a state of emergency,
Okay.
it pops up.
So we have a separate one for that. Otherwise, there's a general consumer complaint form. We have one for senior complaints, for those kind of overseas scams that you probably know a fair amount about. And what we do is really, initially at least, attempt informal dispute resolution. So if a complaint comes in, We send it to the business, ask them to respond within 10 days. And the idea is that we can accomplish some kind of informal resolution for the parties. And then if we start to see some kind of systemic problem, we're getting a lot of complaints about a particular company, then we can build a case and potentially bring a Chapter 75 action. And we do that through affidavits from consumers. And I've realized as I've taken over these contracting cases, they're pretty simple cases. You get a few affidavits from consumers that attest to the wrongdoing. You file your case. I was filing these complaints with like 250 pages of supporting documents, and it was just taking way too long. So I'm a little more nimble than I was, but you know, the evidence is important. So with every affidavit, I would have emails from the consumer to the contractor showing that the work wasn't being done, canceled checks showing payment, text messages showing that the contractor was making up all sorts of excuses. And if you have supporting documents like that for 5 or 6 affidavits, then you have a case that's very strong. And we walk into court, and generally speaking, we'll get a TRO right away. We have a lot of evidence. They have none. They're scrambling to find an attorney. They're entitled to a hearing on a preliminary injunction within 10 days. And generally speaking, we're very successful at getting a preliminary injunction, often without a hearing. And then the case is often moving, and we're litigating, fortunately, from a position of strength. So I'll stop there and field any questions if anybody has any.
I just want to say Tommy get back July 1st.
What's that?
Tommy get back July 1st for Lebanon.
Next year.
July 1st, 2020, yeah.
You are awesome. Okay. All
Can
right.
you extend the time, please?
Okay. All right. July. Okay. All right. Any questions not relating to Tommy Clack? Okay. Thanks very much.